All right, good morning, everyone. Well, it's my pleasure to welcome you to another Chancellor Circle virtual business briefing. My name is James Kniblick. I'm the Director of Development for the College of the Canyons Foundation. On behalf of the Chancellor Circle, our Chancellor, Diane G. Van Hook, College of the Canyons Foundation, and our members, many of you are members today on the call. It is my pleasure to kick things off for us this morning. The College of the Canyons Foundation is pleased to present this virtual business briefing series in service to you of our members and our business community. Today's presentation will feature a presentation by employment law expert, attorney, and friend of the foundation, Brian Koegle. Now, before we introduce our speaker, allow me to address a few housekeeping items as we've done each of these presentations. Now, many of you are Zoom pros by now, but today we're using the webinar feature of Zoom, so we can more effectively manage your questions and feedback. And I have no doubt that there will be many questions and a lot of feedback. So this platform that is looks a little different from what we normally use will help us do that. As you enter the Zoom meeting today, you were automatically muted and your video was automatically muted. And this helps us keep a nice clean presentation, especially for today's topic, as well as cut down any unnecessary noise. So we do want to hear from you, however, throughout the presentation, and Brian will be asking you different times to ask questions, and you'll notice a Q&A button on the bottom of your screen. This is going to be how you actually ask questions. In this format, the chat function, of which many of you are familiar with, is disabled. So you'll be asking questions using that Q&A. We'll be typing responses as well as reading them live. Now, you may want to ask a question live, and if we have time to do so, we will do that. So go, if you would like to actually ask a question using your mic, type in the Q&A that you have a live question to ask, and like I said, if we have time, we'll be able to circle back and unmute your microphone. Well, now it is my distinct honor to introduce Jill Milady, President of Milady Direct Marketing, Co-Chair of the College of the Canyons Foundation Board of Directors, and Chairwoman of the Chancellor Circle Steering Committee. Thank you, Jill, for being available to welcome our guests and Chancellor Circle members today.
Well, thank you very much, James. Good morning, everyone. Excuse my attire. It's a ugly sweater Friday, Christmas sweater. So I'm celebrating the holidays every Friday. Thank you so much for joining us this morning for our business briefing with Brian Koegle, who is sure to entertain you this morning and educate you on the ever-changing employment laws of California. I want to thank all of the Chancellor Circle members for being with us this morning, and I want to thank you all for your continued support throughout the year for all of our virtual business briefing series. On behalf of the College of the Canyons Foundation and the Chancellor Circle, I want to wish you all a very Merry Christmas and Happy Holidays. And at this time, I would like to introduce you to our Chancellor Circle member and partner, Stacy Klein of Logix Credit Union, who has an announcement to make. So go ahead, Stacy.
Thanks, Jill, for the introduction. Good morning, everybody. I hope you're all off to a wonderful holiday season. For the last month, Logix Federal Credit Union and our charity Logix Community Stars has been doing a Double Your Dollars campaign to benefit the College of the Canyons Student Resource Student Fund. And it's been a tremendous success. For every donation that we received, Logix has doubled or matched the donation. On Giving Tuesday, we actually tripled the donations, and it's been such a success. We've actually decided to extend the campaign to fundraise more money for the college, and this will be extended through December 16th. So there's a couple of different ways to donate. If you can, go into a branch and you can, with your donation, get a little, I don't know if you guys can see it, but a little graduate Robux pin, which is adorable and sure to be a collector's item. Or you can simply just go online to custars.org, custars.org, and you'll see a button to donate right away. So, if you can, I know it's a tough time of year, but please try to give a little bit. The school will surely benefit from it. Thank you, Jill.
And thank you, Stacy, and thank you, Jill. This is a wonderful partnership. We are so proud to be able to partner with Logix Federal Credit Union. And thank you, Stacy, for being such an advocate for helping our students. We've made this offer before, but this is our special appeal this year. So if any Chancellor Circle member would like to donate today, not only will your funds be matched, but you can actually put that toward your Chancellor Circle membership. So just let me know if you've made that donation. You can contact Stacy or let me know, and we will make sure that it gets applied to your Chancellor Circle membership for the next year. So wonderful opportunity to not only double your dollars, as we mentioned, but also to continue your partnership of the Chancellor Circle. I want to just quickly mention that we have a very special event in just a little over a week, about 2 weeks, featuring a fellow Chancellor Circle member, T. Meyer. This webinar is sponsored by our alumni network, and it's an alumni network webinar. Definitely for students and alumni, but it can benefit anyone. So it's going to be a great presentation on planning for your financial future, and something I know that our students and alumni will certainly benefit from. Well, it's my honor to kind of just head right into the rest of our presentation. Allow me to introduce our presenter and our speaker today. Brian Koegle is a partner in the Employment and Labor Law Department of Poole, Shaffery, and Koegle. With a focus on labor and employment law, Mr. Koegle provides counsel to employers across various industries regarding hiring practices, employment contracts, wage and hour issues, compensation, discipline matters, personnel documents, and termination matters. Brian's education includes his start right here at College of the Canyons, The Ohio State University, Southwestern University School of Law. And Brian is a proud alumnus of College of the Canyons, as I mentioned. He was awarded the Alumni Hall of Fame as a recipient a few years ago, and has served within a variety of leadership positions within the College of the Canyons Foundation Board of Directors. This includes most recently serving as board chair for a board just the last few years. Brian has offered this presentation specifically to the Chancellor Circle now for the 7th year in a row. And we couldn't be just more grateful that you would do this, Brian. It's a service to our businesses. It's a service to our members. And we are honored that you would agree to return to do so today. So all of you, please join with me in a warm virtual welcome to Mr. Brian Koegle.
Well, thank you so much, James, and thank you to all of the COC Foundation staff. You guys always put on a great show, whether it's in person or on a webinar, so I'm very grateful for the opportunity to speak to everybody in the Chancellor's Circle. This year, this is my very first presentation on the latest and greatest 2020-2021 employment law update, so bear with me if I'm a little rusty because you guys are my guinea pigs today. But I do want to start, and I just want to say thank you specifically to Jill Mulady and to Stacy Klein from Logix. Stacy, I can't tell you how much I appreciate all of the wonderful things that Logix does for the Santa Clarita community, and especially for the COC Foundation. Your generosity and your kindness at Logix are just so very much appreciated. And we kind of need some good news right now, don't we, everybody? It has been quite a roller coaster of a year. And I was reflecting on this year while I was preparing this presentation, and I think about the fact that every single person over the course of the last 7 years that I've done this presentation always come to me afterwards saying, oh, thanks, you made us feel so great about doing business in California. Thanks for all the good news that you provided. Obviously, not a whole lot of good news to share when I'm an employment law attorney first in 2020. So I decided, I think we're going to start with some positive thoughts. I'm going to get everybody to take a deep breath and let's focus on what has happened good in 2020, because it's not much. If you're a sports fan, Lakers and Dodgers have been the champions of the world. For those people who like to get out to the beach, I've got Santa Monica down there, although none of us can go out to Santa Monica. What says happy days like Happy Days, the TV show? And you always have to wrap it up with puppies because puppies are just so doggone cute. I hate to tell you, but this is the only good news slide in the entire deck, and we've got 18 more slides to go through. So for that, I'm sorry, but I'm not the one who makes the laws, I just report them. So where I want to start today is I want to start with obviously what everybody's talking about, COVID-19 implications on business, what it means for you as an employer. I do want to go back and make sure that everybody has a baseline knowledge, because I cannot tell you, even to this day, how many times I get a telephone call in the middle of the week saying, listen, we've got somebody who's now ill at work. I want to make sure that we understand the rules. So let's just go back for a moment and reflect on where we've been since early April of 2020. Congress at the national level passed what was known as the FFCRA, the Families First Coronavirus Response Act. As part of that act, there were 2 additional leave act promises that were made by the federal legislature. The first deals with emergency paid sick leave. If you have an employee who has become ill, who is exhibiting symptoms, who has been ordered to quarantine, or who is caring for somebody who is ill or has been ordered to quarantine, you as an employer are obligated to provide them with paid, job-protected sick leave. What is this you have to provide? Well, basically, if you've got a full-time employee, you're providing them 80 hours, that's 2 full work weeks of paid leave for them to stay at home. Now, in certain circumstances, you may have employees who are physically able to work remotely or telework, as we've come to know it. If the employee is well, healthy, asymptomatic, or if they're caring for somebody in their household and they are able to perform their work at home, you can provide that as a lesser accommodation than providing them the paid sick leave. However, if they become too ill to work, or if they indicate that it's too difficult for them to work from a telework scenario, you must provide them 80 hours of paid sick leave. If you have part-time employees, that sum is prorated. So for instance, if you had someone who worked on average of 32 hours per week, they would be entitled to 64 hours. That's 2 weeks of their regular hours worked. And that is at their regular rate of pay. So if you've got hourly employees, that's their hourly rate. If you've got salaried employees, that's their weekly salary. If you have commissioned or bonused employees, you must take those sums into consideration when compensating your employees when they're out on this extended paid sick leave. And the one thing that is really important, because a lot of employers forgot about this, there is no prerequisite for how long the employee's been with you in order to get this sick leave. You could hire them on a Tuesday and they become ill on a Wednesday and they're entitled to the 80 hours of paid sick leave. And this bank of time is in addition to whatever PTO or paid sick leave or vacation that you're already providing your employees. You cannot, as a matter of law, ask them to take their own PTO during this time period because they are entitled to take this specialized leave under COVID-19. So the emergency paid sick leave was the first portion of this bill. The second part, and much confusion arose as a result of this, was the emergency family medical leave. This is specifically for those individuals who did not recover or who are exhibiting additional symptoms and are not well enough to return to work. Or in those circumstances where they have a minor child, 13 years of age or younger, where they do not have childcare and their schools are closed and they're doing the learning from home. An employer is required to provide up to an additional 10 weeks. So with the paid sick leave plus the emergency family medical leave, we're talking about 12 weeks of overlapping time that is job protected and is paid by the employer. As part of this extended family medical leave, the employee is entitled to receive 2/3 of their regular rate of pay for up to 10 weeks. And again, this is paid by the employer directly to the employee through the normal payroll processes and procedures. The eligibility requirements for the emergency family medical leave is the employee must have worked for you for no less than 30 days prior to taking that extended leave. And it's available, as I mentioned, when an employee can't work or telework, they have childcare issues, their quarantine period has been extended, or they're still exhibiting symptoms that would indicate that they may continue to be contagious with the COVID-19 virus. It is really important for everyone to remember and think about the fact that this is a time where we have to be flexible. This is a little bit of a different scenario than most of the other leave laws. The federal government put this in play through December 31st, 2020. There are 2 bills, one in the Senate and one in the House of Representatives, that are currently pending to extend the COVID-19 provisions of FFCRA through December 31st of 2021. We do not know whether either of those bills are going to be passed as we sit here today. I actually believe that there will be an extension. If there isn't one by January 1st, there most certainly will be, assuming that President-elect Biden comes in and extends by executive order, which he's already indicated he plans to do. Beyond these requirements, beyond the FFCRA requirements, I want to remind every California employer, and I'll talk about something else here in just a moment, but beyond this time period that we have to accommodate and work with employees, we have an obligation under California law known as the Fair Employment and Housing Act. And what it does is it actually extends potential benefits such that we have an obligation to interact with our employees. Even if they've exhausted these 12 weeks of leave, we have to interact and determine if there's a further accommodation that can be provided. Because of that, we have to reflect upon the fact that the associated illness of an employee or the immediate family member is deemed to be a protected category of employment under California law and under federal law. I want to make something very, very clear. We have a lot of folks who have come up and said, listen, I have employees who have just a completely irrational fear. They just are afraid of getting COVID and they don't want to come into work because they don't want to take a risk. Or even they have a rational fear. They're caring for an elderly parent at home and they don't want to take the COVID home. These are circumstances, folks, where employers must interact with the employee. If you do not already have an HR team that's been trained on how to deal with these type of issues, or you don't have counsel that you're speaking to, I strongly encourage you to go out and get that information as quickly as possible, because one misstep in this area will result in litigation. We're already starting to see a wave of claims that are brought in from the first couple of weeks of COVID back in March and April, where people say, my employer didn't do anything to help protect me. They didn't provide me accommodations. I have these pre-existing conditions or an autoimmune disorder, and they didn't take into consideration my medical conditions. So please be careful. Make sure you're dotting every I and crossing every T. And as always, document, document, document everything that you are doing for your employees to make sure that you've got a reinforceable position in the event there's a dispute later down the road. All right, so moving along, the federal rule that I just went over, the FFCRA, when it was passed, it applied to employers that had 500 or fewer employees. California in September extended this protection. They didn't want there to be an exemption for larger employers, those with 500 or more. So AB 1867 was passed and it became effective immediately. And it basically impacts those larger businesses with 500 plus employees in the state of California. It does require mandatory paid sick leave. Unfortunately, under the state program, there is no tax credit available. Under the FFCRA, there's a dollar for dollar tax credit. If you give paid sick leave or paid family leave to your employees, you are entitled to recover that sum from the government when you file your taxes for 2020. That is not true of this statewide extension. It also expands the requirement for intermittent leave. In other words, if an employee tells you that they can only work 5 hours a day, they may take intermittent leave in periods of 2 or 3 or 4 hours in any given day. They may also say, I need to go and visit the doctor every other Friday, and you have to use that intermittent leave accordingly. The civil penalties under California law are very, very important to note. Why? Because there's this pesky program out there known as PAGA. Y'all have heard me speak about it before, Private Attorneys General Act. This basically allows an employee who is not provided the benefits that they're entitled to under California law, under the labor code, to bring a claim not just on their own behalf, but on behalf of all aggrieved employees. It basically becomes an automatic rubber stamp class action lawsuit. So be really delicate if you're one of these larger employers that you are complying with the requirements of 1867. I touched on this in the last slide. Don't forget, in California, we have the FIHA where we have to enter into the interactive process. Under the COVID-19 protocols and procedures that are passed by the state, even the fear of the illness may be deemed a protected category or classification. Be very careful about how you handle that, because it does require an accommodation by the employer. All right, So I got a couple things that are hot off the presses. I want to make sure that everybody's up to speed and knows what's going on. First and foremost, dating back to September 19th, part of the Assembly Bill 1867, employers, regardless of size, if you have one employee, you are required to go through these protective protocols at or at any time right after someone tests positive for COVID-19. If someone in your workplace tests positive, you're obligated to notify all employees who worked in, near, or around that employee of the fact that they've potentially been exposed. Those individuals must be permitted to take time away from work, and they would be entitled to leave under the FFCRA that I previously spoke about while they are tested. California is having a very difficult time, folks, with their testing protocols. Many other states have tests that are available on walk-in clinics or urgent care clinics where results are available within 15 minutes. California right now is dealing with a shortage of those tests. So what we're advising folks from the employment standpoint is you need to count on a 3-day waiting period because that's what it's taking to get some of the lab results back. During that time period, an employee must be paid to stay home. Why? Because you cannot bring them back into the workplace, potentially exposing other coworkers. That would be deemed a willful, intentional, or malicious act by the employer. So the employee stays home while they are tested. If there is a cost associated with that test, please note that you should be covering that as an employer. We'll talk about it in another slide, whether you have to or not. It depends on your size. Additionally, you must have an information sheet up. It should be posted where your poster is located, like in a break room or someplace that's easily accessible for employees. You can just download the CDC guidelines for safe and healthy workplaces, and it needs to be posted advising employees on what their benefits are and protections are under the law. You also must now have a disinfection and safety protocol in place in writing that will be taken in response to any potential exposure. Whether or not you have a positive test or not yet, you must have the protocol ready to go. And then we'll talk about this more in just a moment because the expanded protection of the statewide bill has now been expanded, but you are required to notify local public health agencies of any workplace outbreak. An outbreak under 1867 was defined as 3 or more lab-confirmed cases, regardless of the size of the employer, within a 2-week period. So if over the last 2 weeks you've had 3 or 4 positive tests come back, you now must report that information to the Los Angeles County Department of Public Health if you're an LA County employer, or your individual county public health department if you're outside of Los Angeles County. Additionally, if you have multiple locations in and out of an individual county, you will have to report based upon location. So if you have multiple restaurants, let's say, one in Ventura County, one in Los Angeles County, you can isolate based upon location. If the Ventura County location has an outbreak, you only report that information to Ventura. You're not obligated to report to Los Angeles at this time. Just in time for Thanksgiving, we were given a great gift by California OSHA. Effective November 25th, there were emergency safety regulations which were published. Not many people are talking about this. It wasn't very well covered in the local media or in the national or in the statewide media at all. With very limited exceptions, hospitals, care facilities that have specific carve-outs. Every private employer must publish a written COVID-19 prevention program. It's actually 9 pages long. And I've given you the link here. By the way, as a housekeeping measure, I forgot to mention this at the beginning. At the conclusion of today's presentation, James will be sending out a copy of the full slide deck to every attendee. So you will have all of these links. You don't need to scribble madly right now, but this is the link under which you can go in and obtain the pre-approved Cal OSHA program. If you have your own program, it's all fine and good, but you need to go down and make sure that you have every one of the key elements that is in the Cal OSHA program, because if you're missing even one, it is deemed to be a non-compliant COVID-19 prevention program. Additionally, as effective the day before Thanksgiving, you are required to provide an access tool for every employee to receive training and guidance to prevent the spread of COVID-19. I gave you the link here, but you'll love this. As of yesterday afternoon at 4:55 p.m. Pacific Daylight Time, there is no video that has been posted by CalOSHA. They have indicated that they're working on putting together their webinar training series and the videos for the training of employees. So while the training obligation became mandatory on November 25th, there is no protocol, there is no program for us to utilize at this time. Stand by though, as soon as it becomes available, I will send a blast out on my sidebar mailing list so that you can link into that and provide that as a resource to your employees so that they can be trained on what it takes to prevent the spread of COVID in the workplace. And then finally, as part of the new CalOSHA regs, you are required to keep records of and track any positive tests in your workplace. There is basically a form that you are required to manage. This is regardless of size. I'll talk about a workers' compensation obligation in just a moment, but this is for CalOSHA. If you do not maintain and track the positive tests in the workplace, civil penalties will attach to that, and I'll speak about that in a moment. Failure to comply with any of those CalOSHA requirements that I just went over can result in one of three things. CalOSHA can come out and shut down your work site. The minimum shutdown time period is 7 days. The maximum shutdown time period is 90 days. If they feel that you are acting willfully, maliciously, or intentionally, they may also issue serious violation citations, which will result in not just monetary damages, but a report that goes to your workers' compensation carrier that you are a willful, intentional, and malicious violator of the law. What do you think that's going to do to your workers' compensation rate? And then finally, OSHA has the statutory authority to go and administer penalties up to $10,000 per violation. I mentioned that there are 3 different obligations that you are required to have under that new CalOSHA reg. That could be a maximum penalty of $30,000 if you don't follow these new rules immediately. One other great gift that our legislature gave us in September was Senate Bill 1159. This also has immediate enforcement obligations. Previously, Governor Newsom had passed an executive order that stated that there is a rebuttable presumption that COVID-19 is covered by workers' comp insurance. What that means is that if an employee is continually working and coming into the workplace and they become ill with COVID-19, it is presumed by the law that they contracted the illness at work. And it now becomes the obligation, the burden of proof on the employer to establish evidence outside exposure that the employee became ill outside of work, not inside of work. For those of you who are legal wonks, you understand that whenever a presumption goes against you, it is very difficult to tip the scales back the other way. That means you have to have sufficient evidence to show that the employee was partying up in Las Vegas at a bachelor party where COVID-19 was known to have been, or they were exposed because their wife brought it home from the hospital, something along those lines. Absent evidence to the contrary, though, this would now become a covered claim. What does that mean? In the event that the employee misses more than the 2 weeks of time covered by the Families First Coronavirus Response Act, that means that they would be entitled to take further job protected leave under the Workers' Compensation Act that would require payment by the employer of any hospitalization, medical care, treatments that are received. Additionally, total temporary disability, TTD, payments will have to be made to the employee during the time period that they are incapacitated due to COVID-19 or complications arising from that. So this standard is a little bit different than what is required in that CalOSHA definition of an outbreak, though. Under this statute, an outbreak occurs that in a 14-day window, 4 or more employees test positive, assuming that the employer has fewer than 100 employees, or 4% of your employees if you have 100 or more employees. The other issue that triggers the obligation of reporting to your workers' comp carrier is a local public health department or the state Department of Health issues a citation, meaning that they come in and say, you're a dangerous hazard, you must report this information to your workers' comp carrier. This burden also carries with it the same $10,000 penalty that I spoke about in the CalOSHA issue. If you fail to report an outbreak, as that is defined in these 3 terms, to your workers' compensation carrier, it is an automatic triggering violation of $10,000. Okay, so let's move out of COVID. I wish we could. That is the end of the COVID portion of the presentation. I'm going to take questions at the end. I think that's the easiest way to handle it. If James, I think you'll be all right with that as well. I want to keep momentum going, and I want to shift into portions of the wage and hour discussion today. I put this presentation up every single year. I have this handy dandy little spreadsheet so that you can take a look at where we are today in 2020 and where we're going in 2021. You'll notice that all of a sudden we've got a lot of these big orange blocks filling in, because at the city level, at the county unincorporated level, we're already working with the $15 minimum wage. This goes back to the rules and regulations that were changed back in 2013 on the drive to $15 an hour. What's really important for everyone to note is the way that this works out at the statewide level. If you are a smaller employer with 25 or fewer employees, the minimum wage is going to go to $13 per hour on January 1 and $14 an hour if you have 26 or more employees. The city of Los Angeles, if you've got anyone who works within the city limits or the unincorporated portion of Los Angeles County, they don't change their minimum wage structure until July 1. So those will both be going up to $15 an hour regardless of size as of July 1, 2021. Now, a lot of people say to me, well, listen, Brian, I'm not worried about this because I don't have minimum wage employees. I've got folks that are earning $20 to $25 an hour. The problem that we see, and we have seen over the course of the last 6 years, is that the minimum wage increase typically is having what I call a trickle up effect. If the bottom of the employees are raised by $1 an hour, the midpoint employees are looking to be raised by the same proportional amount. So it does have a dollars and cents effect on your business. Secondarily, the state minimum wage is tied to the minimum salary requirements for exempt employees. I'm not going to spend time going through the exemptions this year because I just don't have time. But you know what they are. They're executive, administrative, professional, computer-related individuals. They must meet the minimum salary threshold as defined under state law. The state law ties the minimum salary to 2 times the statewide minimum wage. In other words, if you're a smaller employer, the minimum salary that you can pay an employee in order for them to be deemed exempt in 2021 is $54,080. If you cross over that 25 threshold, though, the minimum salary becomes $58,240. And in 2022, it basically is going to collaborate and commence and come together such that the minimum salary will be $62,400. You compare that to what the federal minimum salary requirement is of $35,568 a year, and you realize that there is a tremendous difference in the cost of each managerial or supervisory employee that you may be paying on an exempt basis. So just be thoughtful. Remember that right now in December is the time to go back and reevaluate, take a look at job descriptions, make sure that people that you have designated as exempt are truly exempt. Make sure that they're meeting the minimum salary requirements. You may have to bump them up come January 1 in order to meet these threshold numbers. This is the time to be paying attention and to be making changes in preparation for 2021. So there are also a number of new wage and hour requirements, both at the federal and state level. The first issue that I want to touch on is, when is training time compensable? When you are requiring an employee to go through any kind of training, if it benefits you as the employer in any way, shape, or form, it is compensable time under both federal and state law. What does that mean? You must pay them portal to portal for all time spent going through the training sessions that help better them, improve them as an employee for your business. If you're not compensating for training time, you have a violation of both federal law under the Fair Labor Standards Act, as well as California law under the California wage orders. Second, the California Labor Commissioner has now turned into the advocacy department for the state of California. Now, if an employee is mandated to participate in arbitration to defend or to discuss a wage claim, the arbitration is now going to have a representative present for that plaintiff. If they don't have the ability to go out and find an attorney, the state will appoint the labor commissioner to advocate in arbitration on behalf of the employee. Keeping in mind that the California State Labor Commissioner is supposed to be an administrative body overseeing and making decisions, administrative decisions, on whether the employee or the employer was in the right in their wage compensation issues. This is now obviously shifting that direction, and it shows kind of on its face that the Labor Commissioner's office is slanted in favor of employees. Next, it's a reminder. Everybody should know this that pays commissions to their employees, but if you don't, let me just make sure I'm driving this point home. Commissions do not go towards satisfaction of the minimum salary requirements for any of the exemptions. If you are trying to use commissions or incentive-based pay to cross over that $54,080 per year in annual income, you are in violation. It must be a base salary not subject to any kind of contingencies, limitations, or restrictions. If you are trying to use those commissions to gross up the employee above the minimum threshold, you are in violation. And that is a California Supreme Court decision from August of this year. As a quick reminder, if you are not already reimbursing employees for the purchase of their own personal protective equipment, this could include masks or gloves or cleaning wipes if they're bringing in their own stuff, you as an employer are obligated to reimburse those costs to the employee under California Labor Code Section 2802. If you are already providing masks and they choose to bring their own from home because they prefer a particular type or a style or a fit, you are not obligated to reimburse in those circumstances. It's only if you, the employer, are mandating that they provide their own that you are required to reimburse. But it is a really important reminder, and the Labor Commissioner's Office actually sent out a notice, a bulletin on this very issue at the beginning of October. One last thing on reimbursements, we do not have word from the IRS. We were expecting it by last week on the 2021 reimbursement amount for mileage. If you have employees who are driving, although not many people are traveling for business right now as a result of COVID-19, but if you have employees who are required to use their personal vehicle for business use, my strongest recommendation is to reimburse them at 57.5 cents per mile. You're not legally obligated to, but if you're going to do anything other than the IRS presumed redemption rate, you must maintain good documentation and be able to justify why you're compensating them differently. And remember, that puts the burden upon the employer, and we don't like that burden on us if we don't have to assume it. Here's a fun one. The state of California has now required all employers, private employers with 100 or more employees, to provide updated pay data reporting to the state of California. For many of you who have more than 100 employees, you're already used to having to provide an EEO-1 form to the federal government every single year. The EEO-1 form shows pay banding, shows delineation by race and by sex of the employees that you have. Really what it's designed to do is to prevent against acts of discrimination. The problem is, this report actually goes directly into the Department of Industrial Relations. It goes directly to the agency charged with prosecuting employers for being in violation of the California Fair Pay Act. All employers will be required to provide this new notification, this new report to the DIR by March 31st of every calendar year beginning in 2021. My question that I have here as my third bullet point is a very interesting one. Because it's going into a state government agency, I believe that it is subject to a Freedom of Information Act request. The EEO-1 form is designated not to be subject to FOIA request information. The state does not have that same protection. So now all of a sudden, a clever plaintiff's attorney may go out and send out a FOIA request in order to determine whether or not you are paying your employees fairly based upon race, gender, etc. These new reports do require 4 different areas of information. You have to have your number of total employees designated by race, ethnicity, and sex. And the state of California, that is, designate the 10 different job categories. You may stand back and say, well, wait, my employees don't fit into one of these job categories. Well, you're going to have to find one. You're going to have to make them fit, make the square peg fit in the round hole, because that's the way that the government wants it reported. You also will have to report the actual dollar for dollar annual earnings of the employees categorized by race, ethnicity, and sex. We are required under this new report to use the pay bands that are required by the U.S. Bureau of Labor Statistics. That is the same rationale and the same pay banding that we use for EEO-1 reports. So for those of you who are already filling those out, it shouldn't be anything new. We also must disclose the hours worked by each employee, and a separate report actually has to be prepared for each individual establishment. So if you have a retail establishment with 7 different locations throughout California, you will have 7 individual establishment reports and then 1 consolidated report that includes all employees across the board. This is a great reminder, guys, that you should be checking your job descriptions and pay structure to make sure that you're complying with the California Fair Pay Act. I've mentioned this in years past. If you cannot delineate why one project manager is making $55,000 and another is making $240,000 through their job descriptions or different job titles, you are going to have a big problem on your hands. We are seeing huge volumes of Fair Pay Act claims being brought forward to Labor Commissioner, as well as individual civil claims that are being brought in the courts, many of which are now being turned into either class action or PAGA-based claims. This is a great time to get it right, folks. I know it's a lot of work. I know it's a lot of hassle, but going through those job descriptions to make sure that we can justify why we're paying differently based upon different contributions by employees, it is all the more important. All right, within our wage and hour world, I just want to shift really quickly to independent contractor classification. This went into effect on January 1, that's Assembly Bill 5. It scared the heck out of everybody. There were very few carve-outs. It was very, very vague as to how the ABC test was going to apply, and businesses were scrambling to try to come into compliance. Especially with the age of COVID, it made it all the more difficult. AB 2257 was passed in late August and signed by the governor in September, and it basically has specific carve-outs by industry, some for business to business, some for referral services, and some for professional services. These aren't anything new. These are very strong lobbies to the governor's office and to the legislature. If you don't see your business on here, give me a ring, I'll let you know. There were additional carve-outs from 2257, but quite honestly, they do still have a very broad approach, a broad brushstroke on what they want to make sure every person in the state of California is deemed an employee. Why? Because it increases the tax revenue on the payroll taxes. Additionally, it does provide protection for the employees. They are now covered under workers' compensation insurance. They would be provided disability insurance if they were disabled outside of work. Additionally, they would be entitled to unemployment if they lose their jobs. So there are protections in place for the employees. There are burdens on the employer, but now there are a few carve-outs to note. And then for those of you who followed this on November 3rd, Proposition 22 did pass. Uber and Lyft and Grubhub will stay in the state of California, thank goodness. So app-based delivery personnel are going to be allowed to maintain an independent contractor status. Okay, so now let's move real quickly into leave law, because the leave law requirements have been expanded tremendously this year, probably more than what I've seen in the last 7 or 8 years combined. So I want to go through this not too quickly, but I want to be able to move on to some of the other areas that we have to touch on. First and foremost is the expansion of the family and baby bonding leave. This now applies to all employers with 5 or more. It used to be 50, then it moved last year to 20 employees, and now it is down to those employers with 5 or more. It becomes effective January 1, and it basically requires all employers to provide job-protected leave to any employee who needs to care for a family member or take time away from work due to baby bonding. Baby bonding can include birth of a child, adoption, or placement of a foster child. It is 12 weeks of absolute job-protected leave. You can take no adverse employment action against anyone for taking their leave under these new obligations or requirements. For those individuals who are pregnant female employees, this means that the maximum leave is now going to be 28 weeks of leave. You have 16 and 1/3 weeks of pregnancy disability leave available, plus an additional 12 weeks of baby bonding time. Those do not overlap. They are separate and distinct. They may run concurrently, meaning side by side, but they cannot run consecutively, meaning overlapping. The employee may also elect at his or her discretion to take intermittent leave. If they say that they want to take 4-day weekends for the rest of the year so that they can bond with their child, they are permitted to do so. Eligible employees must have worked for the company for 12 months or provided 1,250 hours of service. The reason I've highlighted the word "or" is because it didn't used to be that way. It used to be "and." They had to be there for a year and have satisfied 1,250. Now it's "or." So that means that if you had an employee who worked for you for basically about 7.5 months, they would have satisfied regular full-time employment of 1,250, and they would be qualified for this leave. Failure to comply with these obligations will subject the employer to a claim under the Fair Employment and Housing Act. The claim would be for retaliation, discrimination, and failure to provide access to California Family Rights Act leave. So be very careful, small employers. This is now hitting you square between the eyes. You need to be prepared for this leave obligation beginning on January 1. There is also an expansion of kin care requirements. Many of you know back in 2015, California passed its kin care law, which was codified into Labor Code 233, that allows an employee to use up to half of his or her accrued sick leave to care for a covered relation. But under the old rule, the way it worked was you could obligate the employee to bring in a doctor's note if they were caring for a spouse or a child or a parent or a sibling. You could say, I need a note from your sibling's doctor indicating that somebody needs to be home caring for him or her. Now, you cannot ask for that confirmation. An employee now may come in and at their sole discretion say, I need to use sick leave to care for my child. And you must simply accept that at face value. They do not need to provide any documentation or support. You just must take their word that they are using their sick leave for the care of an immediate family member covered by the kin care law. If you deny any reasonable request by the employee to take such leave, there is a violation of the Fair Employment and Housing Act, and it will subject you to penalties, including punitive damages and attorney's fees. This obligation applies to all employers, regardless of size, one or more employees, because it tacks on to the Healthy Families, Healthy Workplace Act of 2016. There is expanded protection for crime victims. The reason I've spent so much time here laying out these points is because it is a significant expansion on existing leave. If an employee comes to you and they indicate that they need to comply with a subpoena, show up to court, obtain a restraining order, you now have an obligation to allow them to take leave under this new bill. Even if they come to you the same day, I apologize, but I have to go this afternoon and get a restraining order. I'm sorry to have to do this. You must allow them to take that even if they didn't give you advance notice. And here's the other issue with this. This is another one where we must take the employee's word. You cannot require proof that they showed up in court. You cannot require a copy of the restraining order that they went to obtain. Their word is sufficient to trigger the obligations of the employer to provide this leave. For those of you who have 25 or more employees, AB 2992 added an additional obligation in play. These folks must take job protected leave if they're going to be taking leave based upon getting medical attention for an injury that they sustained by a result of any crime or any abuse. If they need to obtain care from a domestic violence shelter, if they want to obtain crisis counseling or psychological counseling, or if they want to go into a safety planning or try to increase the safety for themselves or for their children, you must allow them to take that leave away from work as job protected leave. This new bill will require mandatory notice to be provided to all new hires and existing employees upon request. It will be part of the new posters that are posted by the California Chamber of Commerce this year If you need a link to that, please let me know. I will send it to you. It will be a mandatory notification on that poster. But it does remind us that we need to make sure and go back, and this is an area that your employee handbook should be revised in 2020. Whether it's been 7 years, 7 months, you need to make sure that you are updating your employee handbook to include several of these policies and procedures. Real quickly, taking a step back, I have folks ask me all the time, do we need to put our COVID-19 policy into our handbooks? And the answer is no. The problem that we have with the COVID-19 policies, as we learned from Cal OSHA the day before Thanksgiving, is the rules are constantly changing. If every time we have to change or update our policies, we would have to reissue our handbook, that would be a huge burden upon employers. So I recommend that those policies be maintained separate and distinct from all employee handbooks, but you do obtain confirmation of delivery of those policies and procedures to employees as they're distributed. We have new mandatory reporting requirements. This is actually a really fascinating issue. Any human resources professional that works in your business that is charged with investigating workplace discrimination or harassment claims or claims of retaliation by supervisors have now become mandated reporters under the California Penal Code. What does that mean? If in the course and scope of an HR professional's duties, they find out about the abuse of a minor child or neglect, they are obligated by law to report that information to law enforcement. Failure to report this information to law enforcement results in criminal penalties, including jail time for your HR professionals. For all my HR people out there, my heart goes out to you right now. You've got enough on your plate dealing with COVID-19 and all these compliance issues. Now we have one more burden that's being placed upon us. Not just that, but there's going to be a mandatory training that is obligated for everyone working in HR that has oversight duties of investigations. It's going to help understand the signs of abuse and neglect. The California Department of Social Services has put together an online training program. You will be required to complete that training program before December 31st, 2021. This new law goes into effect January 1. So get your trainings in as quickly as you possibly can. Set up a new protocol or a policy internally on what it is and who is going to be designing workplace investigations, who's responsible for getting this information, and then what the step-by-step process is in order to report that to the proper law enforcement authorities. We also have mandatory wage order violation reporting. This is fascinating. Prior to this bill being passed, the only way that someone could ever find out that there was an award by the California Labor Commissioner's office is if you ran a full search on a business or on an individual. Now, any wage order violation that becomes a judgment or an award by the Labor Commissioner must be reported annually as part of a corporation or LLC's filing of a statement of information. This must include if an officer or director, if you're a corporation, a member or a manager, if you're an LLC, has any final judgment or award issued by the California Labor Commissioner's office or any civil court for, and I quote, any violation of a wage order or labor code violation. It's basically public shaming based upon violations of California wage orders. That's the purpose of what's going on, because violator status now becomes part of the public record. That public record does not get expunged. Even if you take care of that judgment 3 months later, you must still have that statement of information recorded for a period of 5 years. Here's what's really, really fascinating about this new bill. Not only is there the public shaming, the violator status being part of the public record, but any successor to the judgment debtor is now going to be jointly and severally liable for that final judgment. That means that if someone is purchasing a business, they need to obtain clear proof positive that there are no existing labor commissioner or final judgment awards outstanding, because transfer of liability occurs even in asset-only purchases. So if your business is looking to buy or sell in 2021, you need to make sure you're doing due diligence to ensure that there are no outstanding labor commissioner awards, there are no outstanding civil judgments, and that there is no pending legislation or claims because you may be taking an obligation on that you're unaware of. And the strategy of going through an asset purchase only, which is what most businesses do in today's day and age, will not get around the obligations of Assembly Bill 3075. Be very careful in that regard. Okay, California Consumer Privacy Act. Actually, this is a bit of, I guess, okay news. There was going to be a deadline for all of us to comply by January 1st, 2021, meaning we would have had less than a month to comply with the obligations of the Consumer Privacy Act. It's now been bumped out for a year. The reason for that is related to COVID-19. What is at the core of the CCPA, for those of you who are business owners, and there's a whole element of the consumer privacy regarding consumer protections, regarding notification on your websites. All of the other elements are still in play for the CCPA, but the element of employment records is the one that has been delayed for 1 year. Here, a business is required to maintain a policy to make sure that you're ensuring the protection of personal private information belonging to your employees. Social security numbers, driver's license numbers, any identifying data, including addresses, etc. If you are not taking protections to make sure that that is insulated against a breach, either electronically or physically, where someone can come in and obtain that information from an unlocked cabinet or an unlocked office, if you do not have a written protocol in place, you will be required to have it by January 1, 2022. However, it is my strongest recommendation that you address this now. Why? Because if there is a breach in 2021, you will still be liable. You will still be obligated to defend a CCPA lawsuit for the breach of that information. The fact that you're not obligated to just means that there's not going to be a statutory penalty in place for failing to have the policy. Right now is the time to go through your internal processes to ensure that everything that includes a social security number or any personal private information is under strict lock and key, very restricted personnel as to who can have access to that information. If you maintain electronic data, it should be maintained off of your normal servers such that no other employees outside of your HR personnel or your top level executive have access to that data. And it shouldn't, quite honestly, be connected to the internet, because if you get hacked or you have a breach, you will now have obligations to each and every employee whose information may have been compromised. And then finally, we have the extended statute of limitations for claims of discrimination or retaliation under the whistleblower statute. It used to be that if you were a whistleblower, you had 6 months to bring forward your claim to seek administrative redress of your claim. It's basically a right to sue letter that was being obtained. What that does is it basically has now been pushed out to a full 1 year time period, consistent and congruent with many other statutes of limitation for claims of discrimination and retaliation. But what's really interesting about this whole process is it doesn't necessarily change the way that we, business owners, should be approaching this data and information, because there's still a 3-year statute of limitation on almost every other claim under the California Labor Code. So just be very careful. Don't get any false sense of security or false sense of hope that, oh, hey, that person who was a whistleblower, that was more than a year ago, we're safe. There are other claims that can be brought forward that could expose you to potential liability. There is a new Form I-9. It became available in May of 2020. I've given you the link here. Again, James will be circulating these materials afterwards, so don't scribble horribly right now. You will have all of these links in the materials. And then also, for those of you who didn't already do the update after we did our presentation last year, effective January 1, 2020, we must be using a new Form W-4. That is the withholdings certification by the employee at the point of hire or when they have a change in circumstance. Make sure you're using those new forms. If you're using the old forms, it is a $1,000 penalty per form that you're doing. All right, so now let me fly through my last slide and then we can turn to our questions and answers. This is my year end. I do this every single year at this presentation because it's very important and it acts as a great reminder. If you're not already performing an annual audit of your employee practices, policies, procedures, and handbook, you should be doing it. It should be done with a licensed or specialized HR professional, somebody who knows what to look for, or with competent employment legal counsel, people who know how to make revisions to these policies to ensure that they're compliant. Today, we talk about 4 changes that need to go into your employee handbook. Make sure you guys are getting those made quickly, effectively, and then reissuing the handbooks to your employees. When you're reissuing, make sure that they're certifying that they're receiving those documents as well. Maintaining written job descriptions, never more important than they are today, is it? Because of the California Fair Pay Act, because of other issues that come into play, making sure that those job descriptions accurately and adequately cover all aspects of the work that is being done. And it should be a living, breathing document. You should be reviewing the job description with the employee every single year as part of an annualized job review, so that you know what they are doing and what they are not doing any longer, and changing the job description accordingly. Conducting an annual written audit of every exempt employee's classification is also a huge essential part of what you should be doing at year end. These are all of your exempt employees, making sure that they are still doing exempt duties, making sure that they're still doing what they're supposed to be doing, and that they're not productive employees on the line and not managing, directing, administering the work of the business. Be very careful in that regard. Updating your wage claim release. So over the course of 2020, I have had 11 cases on wage and hour violations and information claims that claim meal and rest period violations, work off the clock, etc. I cannot tell you how valuable it is to have an opportunity to cross-examine an employee who says, I was working off the clock for 6 hours a day. And I'll say, at the end of every pay period, you had an opportunity to review all of the time you submitted, correct? Yes, I did. And in fact, you signed a statement that all of those hours were correct, didn't you? Yes, I did. I basically get to play the Perry Mason moment of, are you lying then or are you lying now type moment. But at the end of every pay period, you should have every single non-exempt employee signing a statement that says something to the effect of, all of the hours reflected above are true and accurate to the best of my recollection. I did not work any unauthorized overtime or time off the clock. I received all of my prescribed meals and rest periods, and I did not sustain any known on-the-job injuries during this pay period. They sign it, they date it, and you maintain those records for 4 years post-termination. And they are very, very valuable to have those documents in the event that you ever face a wage and hour claim. If you didn't get to write that down and you'd like me to send you that wage claim release language, I'll be glad to do that for you as a courtesy. Feel free to email me and I will just simply respond to you with my email information. And then finally, in 2020, it has now become a level of malpractice if your business is not carrying employment practices liability. And I'm not saying that lightly. Rarely does EPL insurance benefit my firm and the representation that I have, but it really does save every single one of my clients who has it. It will provide you legal defense. It will help cover indemnity dollars for claims of discrimination, harassment, retaliation, wrongful termination. Some policies in California even have some defense costs covered for wage and hour violations. They're harder to come by now, and you usually pay a premium for them. But if you feel like you have any risk in that area, insuring around the risk now, as opposed to waiting until a claim is filed, is absolutely an essential practice and in every business owner's best interest, especially in 2021. Okay, so I've run just about a minute or two longer than I wanted to so that I can shift over to questions and answers. James, I know we've had about 15 or 20 open questions that have come through. Do you want to start flagging those as we go through?
Yeah, absolutely. Well, first of all, thank you, Brian. I'm just so impressed by the amount of questions and just reflective on how informative this has been and sparking lots of conversation. And we really appreciate your expertise in helping us all navigate these very complex issues. I'll start off with a couple questions for you, Brian, and then if you start reading things that you're seeing what I'm seeing as well, you can kind of go through that. And so just some table talk between me and Brian. Brian, if you feel like you answer something, you can go ahead and click dismiss, and then that way that way I can clear it as well, or I'll clear it once you answer it. Let me kind of kick things off in a reverse order. Most of these questions have to do with COVID-19. Let me ask you a question that on the surface at least does not, and then we'll kind of working backwards into your presentation. We had a participant ask kind of a two-part question. Do we need to reimburse employees for ink, cell phone use if they're requesting to work from home? And if an employer decides to travel, are we required to pay ESPL for their quarantine? I'm assuming that means if the employee chooses to travel on their own.
Sure. So let me address that last question first. If anything is business related and required by the business, then it would be a reimbursable expense. So if you're asking your employees to travel, then you must reimburse it. If they choose to travel, that is their prerogative, that is not on your dime. That goes the same for any other business related expenses. If you are an essential business that remains open at this time, and you have an office where someone can come in, but they voluntarily elect not to come in, that is now on them. You now are not required to reimburse them for paper and for ink in their personal printer. Now, do I encourage this behavior? Absolutely not. But every business is slightly different. It really is a fact-driven scenario. To the cell phone portion of the question, though, that's a really fascinating issue, because cell phones have become so ubiquitous at this point that everyone is just regularly communicating with folks via cell phone as opposed to regular desk phones. Whether or not you're sitting in your cubicle in your office, or whether you're sitting in your home office or at a kitchen table, the use of cell phones has become much more prolific in the age of COVID. If it is now part of the essential business, meaning the day-to-day operation of the business relies upon the employee being able to communicate via cell phone, there is now an obligation for you to contribute and reimburse a reasonable amount for the use of the phone and the data plan that employee may have. What is reasonable? It's different in every industry, and it's different along how much an employee is actually really using their phone for personal use versus business use. So be very careful in your analysis, but I will tell you that sometimes employers will give reimbursement credits of anywhere between $15 to $25, which typically covers a fair amount of use of data and cell phone plan use for business purposes. The one last thing I do want to touch on travel, anything that is typically required by the business or is part and parcel for the day-to-day activities of the business will be deemed a business expense under 2802. If it is the employee who is electing to travel, it would not be reimbursable.
Okay. Thank you, Brian. Question regarding 1099 individuals in COVID-19. Do any of these new COVID safety requirements apply to an entity who only pays 1099 individuals? Are they not employees, correct?
Well, that's a great question. Are you sure that they're independent contractors? If they truly meet the ABC test of Assembly Bill 5, then the obligations for leave, like the FFCRA, paid sick leave, paid family leave, do not apply to them because those are only applicable to employees. However, the safety protocols and procedures do absolutely apply to independent contractors, especially if they're coming into your place of business. Cal OSHA does not discriminate or delineate between employees, independent contractors, third parties, etc. It basically says these are your obligations if you maintain a work site. So you will still be obligated to have all of the COVID prevention protocols and procedures in place under Cal OSHA's requirements. You will not be required to provide paid leave under the FFCRA or the California extension of that bill.
Okay, thank you. So follow up to that FFCRA Act regarding employers less than 10 employees. The question is, are there any California employers exempt based on employee size?
Great question. So the only exemption is for those businesses that have fewer than 50 employees on the emergency family medical leave. That's the extended 10 weeks beyond the first 2 weeks. The emergency paid sick leave applies if you have one employee all the way up to 500. And then of course, the state of California under 1867 extended it above 500. So there's no exemption under the paid sick leave. But if you have under 50 employees, there is an available exemption for that additional 10 weeks, but it is a very, very specific test. You must show extreme economic hardship, basically impossibility to allow the employee to do that as a paid leave program.
Okay, thank you. So it looks like we have a couple questions in one, centering around kind of a retail business scenario where an employee was exposed to another employee whom tested positive and required to go get tested. And that kind of revolving around this. The question states, if an employee is exposed while at work to another employee who is test positive, that employee, the one who's exposed, may take time off up to 3 days to get tested. This person says they were under the impression that the exposed employee must still come to work as long as the protection measures are in place, which is correct.
Well, so let me just make sure I'm clear on this issue. So if an employee is exposed at work and they go to be tested, they do not report to work unless and until they come back with a negative test. If they come back with a negative test, they may be asked to return to work, and you can bring them back into the workplace, assuming, again, all safety measures, social distancing, mask wearing, et cetera, are being followed. If it is a situation where you're talking about the fact that the person may have been exposed outside of work, I still am telling people to be extraordinarily cautious. Why? Because you don't want to take a risk of somebody coming into the workplace and exposing your other coworkers to a potential illness, not just because of the leave obligations, not just because of the lost productivity, but because of the workers' compensation element of things. Additionally, if you cross over that threshold, you're now required to pay, you're now required to report to California OSHA as well as your workers' comp carrier if you have an outbreak in the workplace. So it's regardless of where the person contracts the potential illness. If they are being tested, you keep them away from the workplace until such time that they're able to demonstrate or show a negative test. Additionally, the CDC guidelines were just changed on Tuesday afternoon. It used to be that they were requiring 14 calendar days away from work. Now it is either 7 or 10. 7 days after, if they receive a negative test, they can return after they were positive. So after they're positive, they can return after 7 days if they have shown no symptoms. If they had symptoms, it is after 10 days or after they have 2 consecutive negative tests.
Understood. Follow up on that in terms of the cost of test. If the same individual asks if the employee is not required to take a test, is the employer required for the cost of that test?
Well, if they're not required to, then no, the employer doesn't have to cover the cost of the test. But the question becomes, if you're asking them not to stay away from work, then you're triggering the obligations under the Families First Coronavirus Response Act. So would you rather pay them to sit at home and watch Oprah, or would you rather pay for the $29 test? I think it's kind of like cutting off your nose to spite your face. I'm typically, almost always, recommending that businesses pay for the test for their employees such that they're going to be able to get it quickly and get the results back. Because the other part about it is you want those results. If you make it a mandate that they go get tested and provide you with those test results, you would have to pay for that in that circumstance. You want the test results so that you can make other business decisions, including whether you need to send other people for testing, whether you may even need to close down your facility for a couple of days. I had one manufacturer, they have 85 employees. On a Tuesday, no positive tests whatsoever. On Wednesday, people became getting sick. By Friday of that week, they had 25 people ill with COVID-19. They ended up shutting down their plant for the full 2 weeks in order to ensure that the spread didn't occur further.
Understood. Just if another question from Eric, if employees have been infected outside the work site and not positive at the work site, does this count toward the 3-case reporting rule?
So yes, if it is a positive test of your employee and they provide you the positive test, it goes towards the 3 that you would have an obligation to report.
Understood. Okay.
And unfortunately, the way the County of Los Angeles's statute is written, it's even worse than that. You could have 3 people who get COVID from 3 completely different circumstances. Nobody gets it from work. But if they all come in and say, hey, we're sick, here's our positive test, you're still obligated to report that to County DPH.
Understood. Okay. So Davey and Lisa asked a couple different questions, basically surrounding remote employees and these rules concerning counting COVID tests and things like this. And so maybe extrapolate on this where you seem it's appropriate, but does Cal OSHA tracking and reporting of the cases in the workplace apply to remote working team members?
It's an awesome question, and I don't have an answer for it. We've actually asked that question because it doesn't take into account, at least on the Cal OSHA obligations that came out, the regulations that were issued on the 25th, it doesn't say how we handle work from home or telework situations. Presumably, you've isolated that person because they're not coming into a network of other individual employees. So I believe we have an argument that says that those individuals would not count towards the workplace exposure numbers that need to be reported under the Cal OSHA obligations. Now, with that being said, on the flip side of things, does it change the circumstance on the workers' compensation case? And there, I don't think it does. Why? Because the workplace for the definition of workers' compensation can be the employee's home if they're working through telework. Meaning, if you've got 4 employees, you're a small employer, you've got 4 employees who all become ill working from home, they're still in the workplace because they're working from their home base, and that would have to be required for you to report that to workers' compensation adjusters.
Lori asked a follow-up question in terms of information that you're talking about regarding employees that were exposed and obligations to pay COVID sick leave, et cetera. Where can she find this in writing?
James, would you say that again? Where can she find what in writing?
As far as information regarding when employees are exposed to COVID-19 and obligations of paying COVID sick leave and other obligations.
Oh, okay, got it, understood. Okay, so assuming that you're an employer under 500, you can go to the Department of Treasury or the United States Department of Labor websites. The Department of Labor website is dol.us.gov. The Treasury is treasury.us.gov. And it has all of the financial obligations for the employer regarding paying under the FFCRA, Families First Coronavirus Response Act. If you are larger than 500 employees, the FFCRA doesn't apply. You can go straight to the California Labor Commissioner's Office website. That would be dir.ca.gov/DLSE. And those are government citations. Those aren't opinion based. That's all just FAQ and factual based.
And just as a reminder, I know you have a lot of helpful links and references in your presentation, and this will go out in a few minutes. Brian, we want to probably save a couple minutes maybe for you to go back and maybe comment on anything that you'd like to head off. I have a couple like quickies, I think. It looks like we have a question regarding AB 2992 regarding does this cover foster kids and foster care? Does that make sense?
Yes. So the crime victim. So this is the crime victim expansion of protection. So I don't know the answer to that offhand. If somebody wouldn't mind sending me an email, I will find out for you, and then I will send you the citation straight from the bill. I can't answer that with 100% certainty.
Thank you, Brian. It looks like from my end, that's an anonymous attendee. So whoever wrote that in, feel free to send Brian. comment back to us and we can get that to him. There was another question regarding the recent recent ballot measure. How would you define employees or employers under an app-based employer? I believe it's that 1099 reference.
Yeah. So remember, it's app-based delivery, right? It's not just app-based. It's not just your standard app-based workers or software programmers or stuff like that. It is an app-based delivery worker. And the definition in the code is actually very, very specific. I'll be glad to send it to you. We don't actually have the labor code section assigned yet from what I know as of last week when I put that slide together. I will find out if I've got the actual code section, but I can send you the legislative bill as to what they're looking at for this. But basically, it is very, very limited and restricted. And please note that the concessions that were made by these large corporations, Uber and Grubhub and Lyft, were quite extensive. They're actually paying into a benefit program. They're actually providing minimum guaranteed hours for anyone who wants them. They're going to ensure that there is an alternative disability plan available to the workers, the drivers who are doing work for them. So there are all kinds of other obligations that are tacked on, but they do get to still be qualified as independent contractors.
Thank you. Looks like we have time for a couple more questions.
Yeah, you mind if I field one that Steve asked here just a few moments ago? So one of the questions that was asked is, must all employees, including part-time employees, be provided with paid sick leave? The answer to that is yes. Under California law, the Healthy Workplace, Healthy Families Act from 2016, every employee who works 30 hours a year is entitled to receive paid sick leave. Paid sick leave accrues 1 hour of paid sick leave at the rate of 30 hours worked. So that means if you've got a part-time employee who works 30 hours a week, they accrue 1 hour per week to a maximum cap if you put in a soft cap. This is just generic sick leave acquisition and accrual basis. If we're talking specifically about FFCRA, Families First Coronavirus Response Act, those part-time employees also accrue the additional sick leave benefit, and that sick leave benefit is accrued at a prorated portion. So in other words, if their average work week was 20 hours, they would be entitled to 20 hours per week multiplied by 2 weeks, so a maximum of 40 hours of paid sick leave under the FFCRA. As the second bullet point of that question, if an employee is sick on a day that they were scheduled to work and asks to be paid, do we pay that employee for the number of hours they would have worked that day, or for the hours in addition to what they were scheduled to work? You are only obligated to pay what was scheduled to be worked. So if you had a part-time employee who was scheduled to work 5 hours, you would pay them 5 hours. You don't pay them 8 hours. You don't pay them anything more than what they were scheduled. Now, if the employee does not have 5 hours of accrued time, then you pay them whatever they've accrued. So let's say that they were scheduled to work 5 hours, but they only had 2.5 hours banked of time. You only pay 2.5 hours, and the remaining 2.5 hours would be unpaid time off. Employers ask all the time, can we allow our employees to run negative in their sick bank? That's your decision. That is a policy decision. You're not obligated to let them run negative. The one hazard that I always have a problem with is if you allow an employee to run negative and then they depart, they leave your employment or you terminate them, then there's no way to recapture that money that you forwarded to them. So if you have a plan and you've got long-term employees typically and you don't have a lot of turnover, you may choose to extend, allow somebody to run a negative balance on either their sick leave or their PTO bank, but you need to do it very carefully. And then the third bullet point in that question was, if an employee is sick on a day that they were not scheduled to work, do we have to compensate them for that day? And the answer is no. If they were not scheduled to work, there is not compensable time that the employer has to provide them pay.
Thank you. Well, I think this is the final question, and I'll hand it back to you, Brian, for any kind of final remarks as we wrap up. This is another one regarding travel, personal travel. If an employee wants to travel, for personal related matters, that is requiring to go on an airplane, can we require them to quarantine or get tested?
Absolutely, you can. And that is effective as of November 14th, that you can mandate the quarantine for a period of 14 days if they travel via airplane or if they travel to any region that is deemed to be high risk by the CDC. The CDC map can be found at the CDC's website, which is cdc.org, and you can take a look at where the hot spots are for travel with COVID. You as an employer are absolutely allowed to limit their interaction in the workplace. However, let me flag this for you. If you have an employee who is able to perform telework or is able to work from home effectively and efficiently, you do have an obligation to interact with the employee and, if possible, provide a reasonable accommodation by allowing them to work from home during that time period.
Thank you. Well, again, thank you for everyone that turned in questions. We do have a few left, but I believe we really tackled a good portion of them. Brian, is there anything you'd like to leave us with as we conclude?
No, listen, I'm so very thankful to be able to get in front of a group of people like this that have such great questions and really do obviously care for their employees and for their businesses. It's my pleasure to be able to share this information and to be able to educate the population of businesses that I get the pleasure of working with. It's important to make sure that you're staying on top of these changes so that you're not finding yourself in litigation named as a defendant. If you have any follow-up questions after today, I'd be happy to answer any questions that anybody might have. Obviously, I think everybody knows that this is my area of expertise, so I'm glad to be a resource. I'm glad to be able to tie this in. I'm thankful that the Chancellor Circle puts this presentation on every year. I miss seeing everybody truly face to face, and I'm hopeful that next December we'll be in a position where we'll all be back in the University Center in that conference room so that we can all see each other and maybe not shake hands, but at least bump elbows. So thank you to James, thank you Jill, and thank you Stacy at Logix for everything you guys do. I cannot tell you how much I'm appreciative of all the wonderful love that you guys show this community. If you would like me to, James, I'm more than welcome and happy to stick around for a few minutes after the time period, but I want to honor everybody's time.
Well, thank you again, Brian. It is such an honor to have such a well-spoken expert on the subject, but also knowing you personally, such an advocate for our students and advocate for this organization, the College of the Canyons Foundation. So thank you. We couldn't be more proud of the relationship and long-term work that you provided to us. Again, 7 years in a row, providing this great information to the Chancellor Circle. I want to say thank you to our committee. Stacy is one of them, Jill is one of them, but we have many others that work tirelessly to help put these type of things together. And thank you all for your membership and your continued support of the Chancellor Circle. We hope that you continue to support us. Don't forget about that wonderful match opportunity with Logix, and continue to support each other, and hope to see you soon. So this does conclude the Chancellor Circle virtual business briefing, and we wish you the very best holiday season, and have a wonderful day, everyone. Thank you.